The story begins inside a federal courtroom, not with shouting or spectacle, but with something far more unusual. A government lawyer openly admitting that the system she was working inside was not functioning the way it was supposed to. During a routine hearing connected to Trump-era enforcement actions, a Department of Justice lawyer acknowledged serious internal breakdowns, communication failures, overwhelming caseloads, and an inability to carry out court orders as expected. These were not comments made on television or in a political speech. They were said on the record, before a judge, where words carry consequences. That moment matters, because DOJ lawyers are trained to protect the institution first. They rarely speak in ways that expose internal strain, especially in cases tied to Donald Trump, where every statement is scrutinized and politicized. An admission like this raises uncomfortable questions about how federal cases are being handled, how much pressure lawyers are under, and whether the courts are getting the cooperation they are legally owed. In this video, we examine what was actually said, why it happened in a courtroom rather than a press conference, and what this moment reveals about the growing tension between the justice system, federal agencies, and the legacy of Trump-era decisions that are still unfolding today. To understand why this moment carries weight, it helps to understand how rare it is for a DOJ lawyer to speak this way at all. Government attorneys are not independent commentators. They represent the authority of the federal government in court, and their role is to present a unified, controlled position. When something goes wrong internally, it is usually handled quietly, through internal reviews or sealed filings, not spoken out loud before a judge. That is why this admission immediately stood out to legal observers. The significance grows when you consider where this admission happened. A federal courtroom is not a casual environment. Statements made there are part of the official record. Judges rely on them when making decisions that affect people's rights, detention status, and the legitimacy of government actions. When a DOJ lawyer tells a judge that she cannot get clear answers from her own client agency, or that she is overwhelmed by the workload tied to Trump-era enforcement, it signals more than personal frustration. It suggests structural stress inside the system itself. This moment also lands at a sensitive time. Courts across the country have been increasingly assertive in demanding compliance from federal agencies, especially in cases involving immigration enforcement and executive authority. Judges have little patience for excuses when court orders are not followed. Against that backdrop, an admission like this is not neutral. It places the Department of Justice in an uncomfortable position, caught between defending agency actions and maintaining credibility with the courts. For cases connected to Donald Trump, the stakes are even higher. Every procedural failure, delay, or internal conflict feeds a broader debate about whether justice is being applied consistently and fairly. Supporters see these breakdowns as evidence of chaos and overreach. Critics see them as proof that the system is struggling to clean up unresolved decisions from the past. Either way, this admission became significant not because of who said it, but because of what it revealed about the pressure building inside the federal legal system. To place this moment in context, it's important to understand how DOJ lawyers usually operate and how this situation developed over time. Department of Justice attorneys are assigned to represent federal agencies in court, but they do not control those agencies. Their job is to defend government actions, communicate court orders, and make sure legal procedures are followed. When everything works properly, this relationship is mostly invisible to the public. In this case, the lawyer at the center of the hearing was assigned to handle a large number of cases connected to federal enforcement decisions that trace back to the Trump years. Many of these cases involved fast-moving deadlines, detained individuals, and strict court oversight. Over time, judges began noticing delays, missed responses, and incomplete compliance with their orders. What initially appeared to be isolated issues slowly turned into a pattern that courts could not ignore. Behind the scenes, pressure was building. Caseloads increased, staffing did not keep pace, and communication between lawyers and enforcement agencies became strained. DOJ attorneys were left in the difficult position of standing before judges without clear instructions or timely information from the agencies they were representing. This created a growing gap between what courts demanded and what lawyers could realistically deliver. The background also includes a broader shift in how judges view their role. In recent years, federal courts have shown less willingness to tolerate delays or vague explanations from government lawyers, especially in cases involving personal liberty and constitutional rights. Judges expect accountability, and they increasingly require clear answers on the record. All of this led to the moment in question. The admission did not come out of nowhere. It was the result of mounting pressure, repeated court challenges, and a system that had been stretched thin for years. By the time the lawyer spoke openly in court, the conditions that made such an admission possible were already firmly in place. The core facts of what happened are straightforward, even if their implications are not. During a federal court hearing, a DOJ lawyer responded to questions from a judge about why court orders were not being followed as expected. Instead of offering a routine procedural explanation, she acknowledged on the record that there were serious internal problems. She explained that communication with the agency she was representing was inconsistent, that information was often delayed, and that she was managing an unusually large number of cases at the same time. According to the court transcript, the lawyer described being responsible for dozens of active matters simultaneously, many of them involving urgent decisions about detention and due process. She told the judge that this workload made it difficult to respond quickly and accurately to court directives. She also indicated that she did not always receive timely instructions or cooperation from the agency whose actions were under judicial review. These statements were made openly, without being prompted by media attention or political pressure. The judge's reaction is also part of the factual record. Rather than dismissing the comments as personal frustration, the court treated them as relevant to the larger issue of compliance. Judges rely on DOJ lawyers as their direct link to federal agencies. When that link appears unreliable, it raises concerns about whether court authority is being respected. In this hearing, the judge made clear that court orders are not optional, and that explanations for non-compliance must be credible and specific. Following the hearing, there was no immediate public announcement of disciplinary action or policy changes. The DOJ did not dispute that the statements were made, and there was no formal retraction placed on the record. Instead, the situation remained unresolved, with courts continuing to press for compliance and lawyers returning to their roles under the same strained conditions. These are the verified developments: a courtroom admission, judicial concern, and an institutional response that, at least publicly, has been limited and cautious. What makes this moment so revealing is not just what was said, but what it suggests about how the system is functioning under pressure. When a DOJ lawyer admits in open court that she cannot reliably carry out her role, it points to a breakdown that goes beyond one individual. The evidence indicates a system where responsibility is fragmented. Courts issue clear orders, lawyers are expected to enforce them, and agencies control the information and actions needed to comply. When any link in that chain weakens, the entire process slows or fails. One interpretation is that this reflects institutional overload rather than intentional misconduct. Trump-era policies, especially in enforcement-heavy areas, generated a wave of litigation that never fully subsided. Those cases did not disappear with a change in administration. Instead, they accumulated, leaving current DOJ lawyers to manage an inherited backlog with limited resources. From this view, the admission is less a confession of wrongdoing and more a warning about capacity limits inside the system. Another perspective focuses on accountability. Legal analysts argue that regardless of workload, the Department of Justice has an obligation to ensure that court orders are followed. From this angle, the lawyers' statements expose a failure of management and coordination at higher levels. If agencies are not communicating with their own legal representatives, courts are left without a reliable way to enforce their rulings. That undermines the authority of the judiciary and raises constitutional concern. There is also a political interpretation that cannot be ignored. Any admission tied to Trump-related cases is instantly viewed through a partisan lens. Supporters of Trump argue that these breakdowns show a justice system stretched beyond fairness, driven by political pressure rather than neutral enforcement. Critics counter that the admission highlights how deeply Trump-era decisions disrupted normal legal processes, leaving lasting damage that has yet to be repaired. Both sides draw conclusions from the same facts, even though the facts themselves are limited. What remains clear is what this moment does not prove. It does not establish deliberate defiance of courts, nor does it confirm political targeting. The evidence supports a narrower conclusion. That strain inside federal legal and enforcement systems has reached a point where it is now visible in open court. That visibility is what makes the admission significant, and why judges, lawyers, and observers are paying close attention to what happens next. When this moment is viewed alongside similar developments elsewhere, it begins to look less like an isolated incident and more like part of a broader pattern. Federal courts across the country have increasingly documented problems with delayed responses, incomplete filings, and missed deadlines in cases involving federal agencies. Judges have issued sharper warnings, stronger language, and, in some instances, threats of sanctions to enforce compliance. The common thread in these cases is not ideology, but institutional strain. This pattern reflects deeper structural issues. Federal agencies expanded their enforcement roles rapidly during the Trump years, often without equivalent expansion in legal infrastructure or staffing. When those policies were challenged in court, the legal consequences stretched far beyond the original political moment. DOJ lawyers became the intermediaries, expected to defend complex actions while also navigating changing legal standards and heightened judicial scrutiny. The pressure created by that mismatch is now surfacing in courtrooms. There are also parallels beyond Trump-related cases. Similar tensions have appeared in other areas where agencies face heavy litigation and strict court oversight, such as environmental regulation and emergency public policy actions. In each case, courts have signaled that institutional difficulty is not an acceptable reason for non-compliance. This reinforces a broader message. Federal authority depends not just on power, but on the ability to execute the law reliably. Seen this way, the admission fits into a wider story about how institutions respond when stretched over time. It suggests a system struggling to reconcile past decisions with present legal expectations. The significance lies not in one lawyer's words, but in how often courts are now hearing similar concerns and how firmly they are responding to them. Looking ahead, the next phase of this story will depend less on public reaction and more on how courts choose to respond. Judges have several tools at their disposal, ranging from stricter deadlines to formal contempt proceedings if they believe their orders are being ignored. The key signal to watch is whether courts begin demanding sworn explanations from agency leadership rather than relying solely on DOJ lawyers as intermediaries. Another important factor will be internal adjustments within the Department of Justice. If caseloads are redistributed, staffing is increased, or communication protocols with federal agencies are clarified, it would suggest that the admission triggered corrective action behind the scenes. On the other hand, if similar statements continue to surface in court transcripts, it would indicate that the underlying problems remain unresolved. There are also upcoming legal milestones that could amplify this issue. Ongoing Trump-related cases, especially those involving enforcement authority and due process, will continue to test how well agencies and courts coordinate. Each missed deadline or delayed response will add weight to judicial concerns. The realistic outlook is cautious. There is no clear evidence yet of escalation, but the conditions for it exist. What happens next will be shaped by whether institutions treat this moment as a warning or as just another strain absorbed without reform. Looking ahead, the next phase of this story will depend less on public reaction and more on how courts choose to respond. Judges have several tools at their disposal, ranging from stricter deadlines to formal contempt proceedings if they believe their orders are being ignored. The key signal to watch is whether courts begin demanding sworn explanations from agency leadership rather than relying solely on DOJ lawyers as intermediaries. Another important factor will be internal adjustments within the Department of Justice. If caseloads are redistributed, staffing is increased, or communication protocols with federal agencies are clarified, it would suggest that the admission triggered corrective action behind the scenes. On the other hand, if similar statements continue to surface in court transcripts, it would indicate that the underlying problems remain unresolved. There are also upcoming legal milestones that could amplify this issue. Ongoing Trump-related cases, especially those involving enforcement authority and due process, will continue to test how well agencies and courts coordinate. Each missed deadline or delayed response will add weight to judicial concerns. The realistic outlook is cautious. There is no clear evidence yet of escalation, but the conditions for it exist. What happens next will be shaped by whether institutions treat this moment as a warning or as just another strain absorbed without reform. In summary, the significance of this moment lies not in a dramatic revelation, but in a rare glimpse into the strain facing the federal justice system. A DOJ lawyer's admission in open court revealed pressures that usually remain hidden, especially in cases connected to Donald Trump. The facts show a system struggling with workload, communication, and accountability, rather than a single act of defiance or conspiracy. What makes this matter going forward is how institutions respond. Courts are signaling that patience is wearing thin, and the Department of Justice faces growing expectations to ensure that its lawyers can meet their obligations. Whether this moment leads to reform or fades into the background will shape how future Trump-related cases, and federal enforcement more broadly, are handled.